Greetings and salutations, my fellow sovereigns. This is the Vocational Science Freedom Saturday Night Civics and Sovereignty class, and tonight we'll be continuing our reading from the treatise called American Administration, which we've been doing for the past several nights. You can watch the live stream on Odyssey at the VSOF :8. Okay, so I have the link to the treatise on American Law of Administration. I put it in the chat. The mega link is also in the chat as well, which will contain some other documents. Along with the treatise, it'll also have a list of vocabulary words that I've been taking out just to kind of help people understand all of this stuff, because this particular treatise is fairly detailed. So again, we're going to start back up on page 277, where we left off here at subsection 51, effective subsequent upon prior wills. So a will or a codicil containing revocatory clause sufficiently attested, whether with new testamentary dispositions, revokes the prior will, whether its own dispositions are valid or not. If not sufficiently attested as a revoking will, but valid as to some or all of its testamentary dispositions, it revokes all former dispositions pro tanto. But if its revocatory clause be valid and all other dispositions invalid, its effect will be to render the testator intestate as if he had made no will at all. So let me break some of these down, because obviously there was a lot of vocabulary in there. So a will or a codicil containing a revocatory clause. So what's a revocatory clause? It's a clause that states, hey, this is my will now, and this will that I'm writing now revokes all prior wills or codicils before it. And that's a revocatory clause. And it says sufficiently attested. So to have a proper attestation at the end of your will requires 4 witnesses, which is what we do with the Vocational Science Freedom Status Doc set, because every single one of the Vocational Science of Freedom Status Docs is a continuation of your will, because all of our wills have been probated, because you are considered to be dead to the law, and the trust companies, meaning the DTCC and Fidelity, in conjunction with obviously every single creature that's in the swamp, meaning DC, they are all administering our estates from birth to death. And so it's important for us to create and record our proper wills in the current to revoke anything else that they've ever done up to this point. So that revokes all the prior wills and all dispositions. So dispositions are the things that you state in a will to say, okay, this goes to so-and-so, or that goes to so-and-so, or I want, my piano to go to my aunt, or whatever. That's a disposition, okay? And I'm going to skip down here. So the familiar quotation from Swinburne that no man can die with 2 testaments. So that's the point. So when we come in and we're creating our will and we're putting it down to the public record, all the prior things that have ever been done, all the administration, all of the taking of the res of the estate and placing it into constructive trusts, which they're vast, or minor accounts anywhere, which are also vast, all of those end up being revoked, because the heir of the estate has properly come forward, they've been found to be living, they have come of full age, and they are competent to handle their own affairs, all of which is taken care of by a proof of life and proof of age inquest, which is done by a judicial coroner. So that gets rid of all of the other things that they've ever done as far as the administration is concerned. And because of this reason, no man can die with 2 testaments. Because just remember, we're all still presumed to be dead to the law. Okay, so I'm going to skip down here. And where a second will appoints a fresh executor and the wills are not inconsistent, probate may be granted to both executors. Okay, so what we do is we make sure that anything that they've done prior to us doing this is inconsistent with what we wish to be done as our will. So that way there is then only one lawful executor appointed on public record, and that means that no administrators by act of law can ever administer the rest of our estate, because we have now appointed ourselves as the proper executor. Okay. So I'll continue here. So the Old English cases are of little value as authority on this point, because the appointment of an executor there constituted a disposition of the whole of the personal property of the testator, the residue going to the executor appointed, if not otherwise disposed of. and even under the statutes giving the residue to the next of kin, in the absence of its testamentary disposition, it belongs to the executor when there are no next of kin. And that's important because we're the only sole lawful heirs to our own estates, right? So there can be no next of kin to our own estate when we're the ones first claiming it. And yes, we can have next of kin later if you have children, that's fine. But from the standpoint of what they're doing as to administer our estates from birth to death, the aspect that our own estate has no other next of kin, this applies, okay? That it belongs to the executor when there is no next of kin. That's the point. So we put on our executor hat and say, hey, guys, the whole entire system is done. We demand a full accounting and livery of the entire gross estate. And that's what the power of the executor does. So you're wearing two hats in everything that we're doing. You're the sole lawful heir, which is your rights of blood and kinship, to your own estate. But you're also appointing yourself as the sole lawful executor as well. So that's kind of two separate hats, right? Every will, therefore, in which an executor was appointed constituted a complete disposition of the testator's personal property, which is exactly what we do. The rule in America, at least, is clear that that it is the duty of courts to give effect to every part of every will of the testator. If the several dispositions can be reconciled, the rule of construction being substantially the same where there are several wills to be harmonized, as where there are several clauses in the same will or in wills and codicils. Subsequent wills indeed perform the office of codicils. Okay, so again, this just gets back to the point of that we're going to create our own will because we never had one, because who on earth creates a will before they're 5 years old, which is when the presumption of death kicks in. 5 or 7 is about the age. So we're doing this, we're fixing it, taking care of it. And so there is no other will or situation of which our estates could be administered. Okay. So now I'm going to jump all the way down to page 285, and we're going to be doing a lot of jumping around tonight because there's a lot of extra things. Obviously, in this treatise, it's very, very long, and there's 2 sections to it. This first part is just 856 pages, and then there's a second part as well, which we'll eventually get to. Okay. Subsection 54, revocation by marriage. At common law, right, the marriage of a femme sole works the revocation of any will previously made by her, although she survived her husband, and although the husband at the time of her marriage agreed that the marriage should not affect the will. The rule does not necessarily apply to a will made by a femme sole and operating as an appointment under a power to declare uses, right? So this gets into aspects of were there trusts created, right? Because that's the aspect of delegating a use is within the aspect of a trust. So as early as 1682, the rule of the civil law that where a man made his will and afterward married and had issue, by the way, and had issue, this means had children. They refer to children as issues in the Roman civil law, which is just weird on its own, but that's what it means, okay? And died without expressly revoking his will, leaving issue, children, and wife unprovided for. This should be considered as an implied revocation of his will, was introduced to the courts of England and subsequently adopted by the common law courts. There's a few notes in here. I'm going to go down, I think, just one. Okay, 1. Okay, the reason for this rule is to rest on the disability created by the coverture to dispose the property devised or bequest, whereby the ambulatory quality of the will, that means the death aspect of it, one of the essential features is destroyed. It would follow from this view that the husband dies before his wife without having executed his marital rights respecting the property disposed of by the will. Its validity is thereby restored. And so where the husband acquires no right over the wife's property by marriage, the rule ceases with this reason. And that's the aspect of that if there was some previous marriage arrangement or a prenuptial agreement, right, then the prenuptial agreement applies and takes full force and effect above the natural rights of blood and kinship that would attach to a married couple and or even also the issue as well, the children. So if you have a prenuptial agreement, that's basically in a sense kind of what this is saying. So, okay, so I'm going to skip down. It was a source of considerable dissension between the ecclesiastical and common law courts whether the presumption of revocation rested upon the implied intention of the testator to meet the duties devolving on him from a new state of circumstances, meaning if he got remarried or whatnot, or upon a rule of law tacitly annexed to the execution of the will, resulting in a revocation upon marriage and birth of issue, again, that's children, independently of his intention. The latter view was announced in the case of Martison v. Roe by all the judges of England except Lord Denman, who was absent. And Williams says that these seem to be no doubt that the principles of this case would in future be applied to the decision of cases in this description in the ecclesiastical as well as the temporal courts. Okay, so why did I even underline this at all? Or what I'm getting at with this point is that we have ecclesiastical and common law courts dealing with what? The probate of estates. Because you got to remember that the whole entire jurisdiction of probate started under ecclesiastical jurisdiction. Okay? Probate is not technically anything of common law jurisdiction. What the common law says is the rights of blood and kinship, and so that things pass on to the heirs, and if there's no heir, then it passes on to the wife, and so on and so forth. And there's all kinds of rules of that under the common law. But the idea of probate, the idea of a court coming in and dealing with the property of the dead, is an ecclesiastical creation. Okay, so that's kind of why I wanted to put this in there. And then at the bottom, I specifically underlined this part. Cases of description in the ecclesiastical as well as the temporal courts. So everything that's not ecclesiastical is considered a temporal court, right? But where this started, where the separation of the spiritual and temporal courts started, was William the Conqueror after 1066 in England. He separated the spiritual and temporal courts. Because before that time, they had things like courts of 100 where the people got together and adjudicated matters that were both ecclesiastical and temporal. But when you have William the Conqueror come over in 1066 and he brings along his Roman filthy serpent seed line and all that aspect of the Roman cult, well, then he gives the powers, these separate ecclesiastical powers. So he separates the spiritual and temporal courts. He gives the priests of El the powers of the ecclesiastical courts. And then he turns around and takes over everything of the temporal courts by destroying and basically outlawing the 100 court, which was basically the precursor in England to what we now know as like the grand jury. But it was much bigger than that. It was basically controlled an entire shire. Or another idea or way to think about it is that it was the court that 100 families basically took their business to settle. Okay. All right. So now I'm going to jump down to section 55. Revocation by marriage and birth of issue under English and American statutes. So the common law courts and ecclesiastical courts have been stated above as to what they see regarding these matters. Now comes Roman civil law in the form of statutes. The question of implied revocation by a change in the condition or circumstances of the testator is now determined by statute, both in England and in most of the American states. The English statute of 1837 provides in this respect that every will made by a man or woman shall be revoked by his or her marriage, except a will made in exercise of a power of appointment. And that would be the aspect of the Power of Appointment Act. And this is the aspect of the trusts again. So if there's something that created a trust separately, well, then that sets aside on its own with its own laws and its own rules and whatever the hell the trust says to do, right? So that's the aspect of the power of appointment. But this is an interesting thing, that every will made by a man or woman shall be revoked by his or her marriage. So you're not married, you're single, you have a will. As soon as you get married, what this is stating is that past will is then revoked, because you then enter into the connection with your spouse and the covenanture that goes along with that, and ultimately the creation of your own house and your own family, which then creates a separate and different shield of law, if you will, around the property of those that are now under the house, which includes the man's property. Because before, whatever he had as a will, okay, now that you're married, well, if you die now, well, then your wife automatically has rights to a certain percentage of your estate, and it differs based upon common law and Roman civil law, statutes. But the point is that, and that's referred to as a dower, by the way. And so a widow's dower is a portion of the man's estate that she's entitled to if he dies, regardless of what his previous will or even a will that he creates after marriage states. The widow is always entitled to that dower. So, okay, now I'm going to jump all the way down to page 296. You guys want to follow me down here? Okay, so now we're on to another chapter. This is chapter 7, Origin and Nature of Gifts of Mortis Causa. Alienability, being one of the essential qualities of property, includes the right of the owner to control its post-mortem disposition, even without resort to the solemnity of a last will and testament. Okay, so what is a gift mortis causa? It's basically, I'll just give us an example. So say someone's crossing the road and they get hit by a car and it's clear that they're going to die within a few minutes, that no one's going to be able to save them. And there's a few witnesses around and he says, "Please give my Corvette to my brother." And then he dies. Okay. So that's an aspect of him creating this gift just before he passes away that is then considered to be something separate from a last will and testament, right? So there's that, it's the capacity to do that just before death. And also statements on deathbeds are also things of this ilk. Okay. So I'm going to skip down here. The legal recognition of the donato mortis causa has, as the name indicates, come down to us from the civil law. So this is a Roman civil law thing, this capacity to be able to just kind of give a gift right before death, right? So defined in Justinian's Institutes as a donation which is made to meet the case of death, as where anything is given upon condition that if any fatal accident befall the donor, the person to whom it is given shall have it as his own. But if the donor should survive, or if he should repent of having made the gift, or if the person to whom it has been given should die before the donor, then the donor shall receive back the thing given. So in this aspect, you can also say things like, and another example of this would be, say you're about to cross a very dangerous river, right? And you say to someone before you cross, "If I shall die, please do X with my such and such," right? That's another way of thinking about this aspect of what they're talking about here. Okay, so the donation of property, causa mortis, has never been favored in law. It was carefully guarded under the Roman law, which invalidated every such gift unless proved by 5 witnesses present at the time, every one of whom was required to be a Roman citizen of full age, right? There's that aspect of lack of infancy. So of full age means you're not an infant. Of good character, meaning you're not a felon or someone that's, say, an enemy of the state, and not related to either donor or donee, right? So just a little aspect of that. Now we're going to skip all the way down to page 311. Let's go down here a bit. And again, I'm skipping over a lot of things that deal with, because when you read a treatise of law, they cover every single tiny itty bitty detail of any variance of what could possibly happen in any given situation. So what I basically just skipped over there, that several pages, was all of the little idiosyncrasies that could happen with what we were just talking about, that death gift aspect. So point is that if you ever want to read a treatise on a subject, trust me, if you read the whole totality of whatever that treatise is on, that thing, and this one being the law of American administration, it will explain every single minute detail of what is and what is not in accordance with law. And as we've seen, all different jurisdictions of law as well, right? Unless, of course, you're reading something, a treatise, say, specifically on the common law. Well, then, okay, that's different. But it'll explain to you all the various different jurisdictions as to what happens in each and every different jurisdiction. And if anyone is not fully versed in the various different jurisdictions of law, I highly suggest going and watching the totality of law class. This will give you a very good understanding of the different kinds of jurisdictions, when they apply to you and when they don't. And you can find that on both the VSOF YouTube page and on the VSOF Odyssey. All you have to do is click on playlists, and it's the first one right here, Totality of Law class. So if you need a refresher course in your jurisdictions, I highly suggest that everyone go watch that. And if you've never learned the various different jurisdictions, then I highly suggest that you go watch it, or else much of what I talk about is going to be very, very confusing from people if they do not know the different jurisdictions, okay, and where they came from, which I cover completely in that class. Okay, so, all right, on to this. Descent and distribution of property of intestates. Okay, so what is an intestate? All right, so let's open up our little cheat sheet for our vocabulary. Let's go down to intestate and read what an intestate is. All right, an intestate. One who, having lawful power to make a will, has made none. Or one which is defective in form. In that case, he is said to die intestate, and his estate descends to his heirs at law, meaning at common law. This term comes from the Latin intestatus. Formerly, it was used in France indiscriminately with deconfess, that is, without confession. It was regarded as a crime on account of the omission of the deceased person to give something to the church, and was punished by privation of burial in consecrated grounds. This omission, according to that specific case, could be repaired by making an ampliative testament in the name of the deceased. Now, this obviously no longer happens any longer. No one is giving any this aspect, or has to be forced to give any aspect to the church. But anyway, so what is an intestate? Just one that does not have a will, meaning you had the power to make it, but you didn't make it. So that's what intestate is. Okay, so descent and distribution of property of intestates. Nature and origin of the rules of descent and distribution. In default of the testamentary disposition of the property of a deceased person, the law disposes of the same precisely as the deceased himself would do if acting rationally and without motive or influence of any extraneous nature. The family of a person have claims upon him while living, which are recognized and to a great extent enforced by the law. A man may be compelled to provide for his wife and children the necessities for their support and comfort, and for the proper education of his children. But he may freely alien any of his property during his lifetime, even, as has been shown, on the very point of death, or dispose of the same by last will, subject only to the restrictions as the law imposes for the protection of the wife and the surviving minor children. So what that's saying is that the wife and the minor children have a protection of a certain percentage of the estate, even if it is not stated in his last will and testament. Okay. So to continue, the statutory law of England and America, except in the statute of Louisiana, because it's a Napoleonic law state, allows gifts and devices or bequests in degradation of the interest of his own family, to a greater extent, perhaps, than any other of the civilized nations. Nevertheless, its presumptions and intentments, whenever occasion exists from the application of such, are in favor of the family, or I would say the house. Thus, it is the family which furnishes the basis and content of the law regulating the devolution of the property of intestates. This subject is so thoroughly treated in the statutes of every state of the Union that there is neither room nor occasion for an extensive general discussion for its principles apart from a reference to their provisions. But it may be necessary to bear in mind that in most of the states, the statute of descent and distribution are subject and to be construed with reference to the law according dower. That's, again, a dower is the aspect of what a wife has percentage of the husband's estate when the husband dies. Tenancy by the courtesy, and this is a tenancy by the courtesy is an aspect of that the wife has the right to stay as a tenant on the land or in the house. Partnership, homesteads, we'll get to homesteads in a second, and exemption, and particularly to the particularity, American provisions in favor of the widow and minor children for their immediate support, which will be noticed hereafter. It may also serve the purpose of both students and practitioners to notice that while the American statutes of descent and distribution are exceedingly diverse in their details, They are, in the main, modeled after and mostly approximate in their general results to English statutes of distributions, which in its turn is mainly borrowed from the civil law, so that the construction and practice under it have been governed to a great extent by the principles of the civil law. So basically, what does that say? It says that we're still being controlled in certain aspects by English statutes, particularly the English statute of distribution. And what is that? They're telling you it's Roman civil law, right? But because we adopted it here, many of these English statutes are still in full force and effect, right? So it's important to remember that, not just in dealing with estates, but in dealing with basically everything that the English statutes would have stated that have not specifically been altered by American state Roman civil law statutes, acts, ordinances, and codes. They're still in full force and effect from what it said in England to here. Okay, so skipping down to page 314. It is to be borne in mind that the distribution of personal property of an intestate, again, one that doesn't have a will, must be according to the law of the country or state of which he was a domiciled inhabitant at the time of his death, without regard to place of either the birth or death or the situation of the property at the time. But that real estate descends to the law of the place where it is situated. So meaning, okay, so let me break that down. It is to bear in mind that the distribution of personal property of an intestate must be according to the law of the country or state of which he was a domiciled inhabitant. Okay, domiciled, not a resident, but lawfully domiciled. Because you can have many residences, but you can only have one domicile. Okay? And if you are domiciled there, then that's the place where you are an inhabitant. And that's important to understand, because one that is a resident, or if you ever read anything in law, if you read say some county ordinance or something, and it says every resident must, XYZ. Well, if you're lawfully domiciled there as an inhabitant, that statute doesn't apply to you because you're not a resident. Okay? Residence is a temporary term. If you're a resident somewhere, that means you're there temporary, doing business, and whenever you're done doing your business, you'll go back to wherever the hell it is you came from, right? So that's a critical thing to remember. And we always state that we are lawfully domiciled and that we are a lawful inhabitant and that we are one of the people of, whatever state, whatever republic that you're at, right? So, and then without regard to the place of either the birth or death. So it doesn't matter what, so if you're born in California, fine. But if you're lawfully domiciled in Wisconsin and you're a lawful inhabitant thereof, well, then that's where the distribution of personal property of an intestate must be according to the law of the country or state, right? So meaning that you can go through and make claim and have livery at the proper county probate court. And you're going to be obviously we're going to be doing probate in solemn form here. So you'd open up a probate case in solemn form in the county of which you are lawfully domiciled and an inhabitant. That means meaning you would not have to go all the way back to the birth county to go take care of this. Okay. That's more along the lines of what this says. And I'm obviously connecting it into what we're going to want to eventually have to do to have our entire gross estates back. Okay, so to continue. Nor can the decedent be governed by a statute not in force on the day of the intestate's death. Well, obviously, that'd be like an ex post facto law. Or so a vested remainder descent to under the law in force at the time of the vesting of the estate in expectancy, not affected by the law governing descents at the termination of the intervening estate. Okay. So the term descent is usually applied to the devolution of real estate and distribution to that of personal property. Okay. So when we're talking about the land descents, so that's what they're talking about. They're talking about real estate or land. Distribution is all of your stuff. Your piano, your bed, your computer, whatever. So that's your distribution. So when we come forward and we're demanding our entire gross estate, we're demanding both of these things: what lawfully shall descend to us and what is lawful as per distribution to us as well, right? Okay. And in most states, a distribution is still observed in the devolution of these two classes of property, arising, no doubt, from the former tenure of real estate under the feudal system. Right, because what are they trying to do? They want their feudal system back, right? So they're still keeping these things in full force and effect. Okay. All right. So subsection 65, rights of children. The legitimate result of the ethical union of the sexes is the continuance of the race, which is thus seen to depend for its permanency upon the marriage institution and its direct result, the family. As the instinct of self-preservation is the highest law of all living things, so it is an overruling necessity for the state to vindicate and preserve the family, whose extinction it could not survive. Well, yeah, but that's exactly what the state is doing right now. What the communists are doing is they are intentionally trying to destroy the entire family, right? Because they don't want any state to exist. They want absolute 100% chaos. No structure of the family. Certainly, they don't want people creating their own houses and making sure that all of their lawful property is protected thereunder. But it goes to the point, whose extinction it could not survive. So the families and the houses come first, then the state is created afterwards, because obviously we vest power to them to go do certain enumerated tasks for us that we don't feel like doing on a daily basis. And then we are the creator, they are the created, and they exist by our will in the form of a constitution. Okay. So to continue, in recognition of this necessity, all states have at all times secured to the several members of a family, in the strict sense, father, mother, and minor children, the enjoyment of their common property by representation through its head, meaning the paterfamilias of the house, and the civil canon and common law, as well as the English and American statutes regulating the descent and distribution of the property of deceased intestates, are unanimous in placing children and the descendants of deceased children, the intestate, in the first degree as heirs. So what's that saying? It's saying that anybody that's intestate, all of these aspects of law, the civil, that's Roman civil law, comma, canon, which is ecclesiastical, comma, and common law, comma, as well as English and American statutes relating. So those are all these different aspects of law, right? So they're all saying that the descendants of the deceased children of the intestates in the first degree as heirs. So they're saying, okay, even if you didn't make a will, all of these laws, all these jurisdictions clearly see that in the first degree as heirs, the children in the first degree as heirs. And what obviously all of them also see is the aspect that a man may come back forward and claim his entire estate after a presumption of death as well, which it does state later in this document, but we'll get to that maybe the next time we get through reading this. Okay, so to continue, the apparent exception to this at common law and under the statutes of some of the states following it, of a husband taking a personal property of a deceased wife in exclusion of her children, is not an exception in reality. For at common law, the personal property of a wife is that of her husband, right? Because at common law, there's one marriage. At common law, you're both under the same house, right? So that it cannot strictly be said that she die intestate as to such, because she had none to leave. Nor is it strictly considered an exception to this rule to allow the husband of a deceased wife to enjoy her lands during his lifetime, or to accord to a widow her dower estate. For in either case, the surviving parent is bound as the head of the remaining family for the support of the minor children, and the property thus still goes to the benefit of such. And this is part and parcel of the reason why we make sure that we create our own house. So all of this gets protected under that aspect. Okay, so now we're going to jump way down to page 342, illegitimate children, subsection 75. Now, remember, before I start this, I'm going to make a point here. Remember that in this current Luciferian system of slavery that they have created and have us all in and under. What they're doing is they're making us all be illegitimate under the law. Because if you read the birth certificate, it'll have the father's name and the mother's maiden name, not her married name. So on the birth certificate itself, it creates a situation, by presumption, that the child is illegitimate, is a bastard. Okay? And according to the common law, as an illegitimate child is filius nullius and can have no father known to the law. He has no inheritable blood and can therefore be the heir to neither his putative, I don't know if I'm pronouncing that right. Putative, I guess that's putative, father nor mother, nor anyone else, and can have no heir but of his own body. Okay, so there's a few things to unravel there. So at common law, if you're considered a bastard, you don't have a father known at law, and therefore you have no inheritable blood. So that's why they do what they do on the birth certificate, to make it clear that it looks, by presumption, but it looks clearly that you're a bastard. But then that other part right there is very interesting. That last little part right here, it says, but to no one else, and can have no heir but of his own body. Okay, so right there, it shows that you can be an heir of your own body because it states it right there, right? And that's exactly what we are doing. We are saying, look, we are the heir of our own body. Get off of me. I don't want your administration. I don't want your Roman civil law filth. I don't want your statutes, acts, ordinances, and codes. I'm not subject to the jurisdiction of Congress under the 14th Amendment. I'm not dead to the law. I have all of my inalienable rights, as by nature and nature's God, as Jefferson so put. And I do not want to have any contracts with you. Thank you very much. Now go fuck yourself. Because that's what we have to get rid of. All of these presumptions and all the contracts that would take away the capacity that you are the heir to your own body. And that you're a bastard and all the rest of these presumptions go along with it, right? So it's important to know that, and that's exactly what we're doing. That's exactly what we're getting rid of. Is anything that would get in the way of you being the heir of your own body, okay? Because if you're not at least the heir of your own body and get rid of the illegitimate child aspect, you can't hold title to anything. Aside from the fact of the infancy problem, right? Say if you got rid of the infancy problem, if you're still a bastard, you still can't hold title. So all of these things have to be systematically taken care of. They have to be rebutted correctly on the public record, or else they stand. Because an unrebutted presumption will have full force and effect in court unless it is rebutted. Okay, to continue. The rigor, not to say cruelty, of the civil law, well, that's debatable, which denied even maintenance of the fruit of incestuous intercourse, and of the common law, allowing a bastard no rights but such as he himself acquires, and renders legitimation impossible, although the parents marry after birth, has been much relaxed in the several states of the Union. Meaning, you have a bastard child, but then the two parents get married. Okay, well then they look at that like, okay, it's no longer a bastard, basically. Thus, they are almost universally allowed to inherit from the mother and through the mother. And in Connecticut, where the statute gives the estate to the children of an intestate without in any way qualifying the word, it has been held that illegitimate children were thereby included. Okay. In some of the states, the illegitimate offspring may also be enabled to inherit from the father if the latter, meaning the father, acknowledge him in writing in the presence of a competent witness. Okay. That's what nobody's doing. But that's what we're doing. We're saying, hey, the father comes along, they do the status doc set. There is an attachment that goes along with one of the status docs that claims the children, where the father then acknowledges in writing in the presence of competent witnesses to say, yes, these are my children. And these are the warehouse receipts, meaning the birth certificates, that I am now endorsing and taking all of their estate in total as being their executor under the protection of my house. Okay? So it's very important. And this is the reason why we do this, because I already knew this aspect of law, that in some states, the illegitimate offspring may also be enabled to inherit from the father if the father acknowledge him in writing in the presence of a competent witness, right? And if you go to 6, which is the little note here, so we come down to 6, it says, so provided in California, Iowa, the paternity be notoriously acknowledged, okay, so that means by notary, or acknowledged in writing, or proved during the intestate's lifetime as to evidence sufficient to establish notorious recognition. The acknowledgement must be recorded like a deed. I didn't even underline this, but this is extremely important. The acknowledgement must be recorded like a deed. Why do you think we record everything on the public record, folks? This is the reason. All the acknowledgments, all of what we're doing, the proof of life and proof of age inquest, all of the vocational science for freedom status docs, which are all juristic acts, by the way, which also need to be acknowledged and recorded like a deed. But this is the point. So the acknowledgement of the father, because remember what we're talking about here, the acknowledgement of the father that the children are legitimate, must be recorded like a deed. So that's why we do this, okay? So I'll scoop back up here and get back to where we were. All right. Okay. Precedent, competent witness, and the subsequent marriage of the parents legitimates their issue, their children, if acknowledged by the father. So whose turn is it here? Whose duty does this fall upon? The paterfamilias, the father, to claim the children, right? Because they give you an announcement in the paper that a baby boy or a baby girl has been born, right? If you go look up the definition of A, by the way, in Black's Law Dictionary, you'll find that the definition of the letter A, and yes, it does have its own definition, can be considered to be a stock announcement. Okay, what are they doing? They're announcing the new stock. Father doesn't come to claim it. 7 years, abandonment, presumption of death, all the rest of this shit kicks in, right? And then after 21 years, the presumption that they're citizens of the United States kicks in as well, unless rebutted, right? So again, this is all by presumption. But again, if acknowledged by the father, nearly all states canceling all distinction between such children and those begotten and born in lawful wedlock. If an illegitimate child is once legitimized by the subsequent marriage of the parents in a state whose laws attach such effect to such marriage, the legitimacy follows the child everywhere and entitles him to the right of inheritance. In some of the states, illegitimate children take as heirs from father or mother as if there are no heirs capable of taking, so that they exclude the state only. The word heirs in such case is not confined to children. It includes all who may inherit under the law. So you can call somebody else your heir in your last will and testament that doesn't necessarily have to be your children, okay? And then that counts as the word heir. It is also be observed that in some states, the issue of marriages, again, the creation of children of marriages, which are null in law, in every respect legitimate, and inherit and transmit by descent, as if born in lawful wedlock. In states recognizing neither lawful marriages nor property rights, enslaves, the laws of descent did not, of course, apply to them. In states recognizing neither lawful marriages nor property rights in slaves, meaning the slaves doesn't have any property rights at all, and the states didn't, recognize lawful marriages, the laws of descent did not, of course, apply to them. So remember, folks, this is just more presumption, more aspect of being a debt slave, a bonded debt slave. Bondsman, someone who's bonded. Yeah, you're bonded because the fidelity bond connects to your BC. And all you have to do is just go get that report, go get it audited, find out how much is in there. But the point is that your ass is bonded. So by definition, you are automatically a debt slave until you get rid of all this shit, okay? A statute passed after their emancipation, meaning slaves' emancipation, declaring that children of colored parents born before a day named of persons living together as man and wife should be legitimate children, with all the rights of heirs at law and next of kin with respect to the estate of such parents, was held in North Carolina as entitling them to inherit from such parents only, but not from any other person. Right. So in Florida, where the slave marriage terminated before was never recognized by the parties after they became free persons, the offspring thereof have no inheritable blood, and they can inherit no property acquired by the ancestors after emancipation. And in Tennessee, the right of direct inheritance only, and not the right of collateral inheritance, is conferred by such an act. The death of a bastard intestate, his descendants take as if he were legitimate. So if you have a bastard and then the bastard has children that are legitimate, then his descendants take as if he were legitimate, meaning that the aspect of how the law sees the distribution and the transfer of property basically stops with the bastard. But of course, under this system, everybody's considered a bastard, right? So therein lies the problem. And one other thing I want to bring up here about this whole the aspect of what they're talking about with the slave thing. All marriage licenses started with the marriages of black and white. That's called intermarrying. And that was where the marriage contracts, marriage licenses started. Because remember, this is another thing you got to remember. Slaves were emancipated, but at the same time, what happened was that the United States Federal Corporation basically picked them all up, and they went from being private property to being public property under the DC swamp, right? And everything that they're doing, from being a subject of the jurisdiction of Congress, right? And then what they did was they roped all the white people into it afterwards by presumption and contract and pledges and everything else that they're doing, right? So, but the point is that marriage contracts, marriage licenses started out by that aspect of people intermarrying. So if you are going to go and get a marriage contract with the state, you have to remember that contract is a three-party contract. You, your wife, or significant other, and the state. There are three parties. And there's a meme in the meme section of the VSOF Gilded server, under the law memes, that specifically takes a screenshot from a definition of marriage where it specifically states that it is a three-party contract. Okay, where did that come from? It came from this whole aspect of the slaves, right? So we're still wandering around here, not paying any attention to what's going on, and walking into these contracts and having not the slightest idea what they do to us. Now, would I go so far as to say that anybody that has a marriage license would be considered a slave? I wouldn't go that far. But there's obviously the connection is already there, right? So, okay. Section 76. Descent from and through aliens. Okay. Now, before I get into this, I want to make a point here again. We, the people of our respective states, being lawfully domiciled and a lawful inhabitant thereof, are foreign to the District of Columbia and Congress thereof. Okay? When you're looking in United States Code, the term that you really want to find is foreign state. That's what you are, and that's what you want to be in respect to DC and the United States Federal Corporation. You want to be a foreign state, okay? And when you're a foreign state, you have all of your power and all of your law, right? But there's a certain aspect of being an alien. If you are an alien in some location, some other jurisdiction, like say, for example, in DC. So if you're a resident alien, you do not have the same rights as someone who is lawfully domiciled there or one of the people thereof. Now, of course, you can't be a people of DC, but just say you were in the part of Maryland, right? Whatever, or Virginia, right? So if you're lawfully domiciled, you have the capacity of your full rights. But if you're an alien, there's certain aspects that you do not have, which this will get into. Okay. So descent from, to, or through aliens. It is evident that the descent of real estate from, to, or through aliens is affected by the question of alienism to the extent only in which an alien is capable or incapable of owning real estate under the law of the country or state in which it is situated, meaning the land is situated. It is mentioned in connection with the testimonial capacity of aliens that public policy requires that no alien, whether friend or enemy, shall have title to lands as against the sovereignty, though, at the common law, an alien may acquire by purchase, including devise, and even bring an action for lands and hold them until the government, the principles of policy, interfere, and by office found deprive him of his title, or under his death when an alien when an alien can have no heirs, it escheats. Meaning the land escheats. Okay, but let me break this down before I get to a sheet here. Okay, so from through aliens is affected by the question of alienism to the extent of which the alien is capable or incapable of owning real estate under the laws of the country or state in which it is situated. So when they have this public policy under statutes, acts, ordinances, and codes that aliens may not do this or aliens may not do that, so on and so on and so forth. Well, if you're considered an aspect of an alien or even an aspect of an enemy combatant, right? Because we have that presumption and that problem as well, that they did in Trading with the Enemies Act. I don't remember the year that was, but basically they made all of the citizens of the United States, meaning the 14th Amendment citizens, basic enemies of their own corporation, which was insane, but that's what they did. And so if those presumptions are against you as far as the alien situation is concerned, well, then you're subject to public policy, right? So just want to make a point of that. Okay, now I can get to a sheet. All right, so let's pull up a sheet so you guys can know what a sheet means. So up to a sheet is title to lands. According to the English law, a sheet denotes an obstruction of the course of descent, meaning descent, because remember, descent is when lands are passed from heir to heir to heir to heir. That's descent, right? And a consequent determination of the tenure by some unforeseen contingency in which case the land naturally results back by a kind of revision to the original grantor or lord of the fee. That's Blackstone's Commentaries, page 244. Number 2, all escheats under the English law were declared to be strictly feudal and to import the extinction of tenure, because the king was the one that owned all the lands, okay? But number 3, but as the feudal tenures did not exist in this country, meaning America, there are no private persons who succeed to the inheritance by a sheet, meaning there's no king, right? The state steps in, notice that's lowercase s state, by the way. The state steps in the place of the feudal lord by virtue of its sovereignty as the original and ultimate proprietor of all lands within its jurisdiction. Now, again, lowercase s state means what consists of. That's the land and we the sovereign people. Okay, that's lowercase s state. It seems to be universal. It seems to be the universal rule of civilized society that when the deceased owner has left no heirs, it should vest in the public, us, we the people, and be at the disposal of the government. Okay, Jones, and for the rules of civil law, see the Code of Justinian, so on and so forth, right? So, but what happens? So, someone is an intestate. They don't have a will. Okay, they leave no heirs, meaning they don't have any issues, right? They've never had any children. Okay, where does the land then, what then happens to the land? The land then escheats. That's what this definition is. And what happens is when the land escheats onto or back to the state, what the state has to do is then put it up to auction to whom? The sovereignty, all of the rest of us, all of we the people. That's what the state's purpose is when they're going through this process. And there's all kinds of rules about escheats. And in some states, there was even the creation of a board of escheats by, I think Michigan's one. If you read the original Michigan Constitution, they actually have a board of escheats that is actually constitutionally created, which no longer runs anymore because what they did is they altered it by, I don't know if they really couldn't alter it by statute. They would have actually had to have amended the Constitution. Which, funny, you know what? I don't think they did amend the Constitution to move it. I think they just created a statute and they threw it underneath the treasurer of Michigan, which was weird. Yeah, come to think about that now, I never did find any place in the Michigan law that stated that they. Now, I'm not. Don't hold me to this totally, but I don't think in any place in Michigan law they ever actually amended the Michigan Constitution to allow the Board of Escheats to then for the powers of the Board of Escheats to then be given to the state treasurer. But they did create something by statute to just quote unquote move it over there. But because of the fact that it is a constitutionally created entity, they actually can't do that without amending the Constitution. But anyway, so sorry, not to digress. Okay, so that's what an escheat is. All right, back to the treatise here. Okay. So again, or until his death or when the alien have no heirs, it escheats. So it goes back to the people, basically. Okay. All right, so then we're going to skip down a little bit here to section 77, nature and office of statutory allowances for provisional support of the family. This is the aspect of alimony and family, or the things of like dower and things of that kind. It has already been noticed that the power of testamentary dispositions is limited in some respects by the policy of the law, which places certain rights beyond the caprice of the testator. The common law secures the widow her dower, and to the widow and children their pars rationabilis, according to dower and distribution under American statutes. But no provision whatsoever is therein found to meet the exigencies arising immediately upon the death of the head of a family, save perhaps the clause in Magna Carta securing to the widow the right to remain in her husband's capital mansion for 40 days after his death, within which time her dower was to be assigned. Okay. We're talking about the Magna Carta. As I said, remember, the Magna Carta is in full force and effect. If anybody doesn't believe that, you can just come read this little part of this treatise. It says it right here. So it's important to understand and read the Magna Carta as to what your rights are, particularly regarding the rights of blood and kinship and your rights as an heir to have your estate without fine and without fee, specifically Article 3, 4, and 5 of the Magna Carta. Those are some of the most critical articles in the Magna Carta as to what your rights are to have your estate without fine and without fee when you, the heir, comes of full age, which is not a number, meaning not 18. And by the way, the term come of full age is completely different than the term age of majority. Age of majority means that you can join the democracy, right? You can be a majority in the democracy. But come of full age means that you have the capacity to handle your own affairs and that you then can make claim to your entire gross estate. Okay, so now we're going to skip down to page 384, which is quite a jump. Roll down here. Exemption of the homestead. So I'll probably cover this and then probably quit for the night. Okay, so chapter 10, exemption of the homestead. Nature of the homestead right of the surviving family. The policy which dictates provision of the support of... Oh, I was going to show the homestead picture as well. Well, I'll read this and then I'll do the picture because there's a picture in the mega folder that I wanted to bring out and make a point of. Okay, so nature of the homestead right for the surviving family. The policy which dictates provision of the support of the family immediately after the death of its natural provider and protector also requires the homestead to be secured to the surviving husband or widow and minor children. The obvious intent of homestead laws is no less to secure a home and shelter to the family when bereft of its father or mother beyond the reach of financial misfortune, which even the most prudent and sagacious cannot always avoid, than to protect citizens and their families from the miseries and dangers of destitution by protecting the wife and children against the neglect and improvidence of the father and husband. The homestead exemption would be devised of its most essential and characteristic feature if, upon the death of the head of the family, it should be withdrawn from the widow and children. Hence, nearly all the statutes upon this subject provide for its continuance for the surviving constituents of the family. It has been held that the, quote, the exemption is not to the debtor as such, but to the head of the family, the subject of the protection of the family, the head of the family being referred to as its representative. It would be an unreasonable and unnatural conclusion to hold that this provision was not intended for the security of families deprived of their natural protector. That the head of the family must be the debtor in order to secure such protection is neither written in the letter nor within the spirit of the law, right? So it's protected no matter what, regardless of who might be a debtor to the estate, right? Or whenever there is a family and a family homestead, it is to be presumed that there is a head to the family, one or more peculiarity charged with the responsibility for the protection of the family, and the homestead is to be regarded as the head of such family within the meaning of the Constitution. The homestead exemption descending to widows and minors is not strictly an estate or property given as such to those entitled to it under the homestead law, but rather a privilege extended to the beneficiaries thereof, protecting them in the enjoyment of property to which it applies against the claims of creditors. So get that. Against the claims of creditors or the rights of adult heirs, even if regarded as an estate in legal contemplation. It is that of particular kind which exists rather than incidental to than independent of other estates. So the homestead aspect of, and by the way, there are homestead exemptions which you can find in, I don't know if they exist in every single state, but I know they exist in Illinois, Michigan, Florida, Wisconsin, I think Missouri, and Iowa also.
They are not in every state.
Yeah, I know they're definitely not in every state, but the one I'm trying to remember the ones that they are, and don't hold me to that too, because they might change these things as well, because the homestead exemptions are things that the attorney really doesn't like, and the Luciferian globalists really don't like either, because it gives protection to people instead of the banks, basically. And to bring up that point, I was going to open up the homestead picture and show you guys out of the mega file here. So this is somebody's post from Twitter, but anyway, it says farmers arrest the sheriff who is attempting to evict a woman from her farm on behalf of an insurance company. And this is in Michigan, 1952. There's a big sign here that says, this is exempt property from seizure. This is a widow's homestead. And they've literally got the sheriff on his back in the dirt around, I don't know how many men this is. So they arrested the sheriff and said, what are you doing? You do not have the capacity to do this, and we're going to arrest you because you're a moron, because he's not following the law. And that is not only because the picture is true, but it's true at any point. If anyone, any cop, any stupid black robe priest of hell, any sheriff's deputy, I don't give a fuck who it is. If they are violating the law, you can arrest them. Period. That is your right to do so. But then your duty, after you do that, is to take them directly before the nearest and most accessible magistrate in that county, because you cannot punish them until they've had their time and day in court. So you take them directly to the closest magistrate. If that happens to be your fucking neighbor, then do it. You knock on the door and say, hey, magistrate, I got somebody that I arrested here. This is the reason why I arrested him. And here are my witnesses. And right then and there, that is the evidentiary hearing that the magistrate hears and then can create a warrant directly from the testimony of the people that arrested him. I don't give a shit what it's for. If he violates the law, arrest him. You can do that. Totally lawful. Right? And some of these cops had better start waking up to that fact. Because I can guarantee you, when we start forming 25-member grand juries and we have militia that are protecting them, and some sheriff or some deputy or some stupid pig tries to come and break up the grand jury, we are definitely body slamming them on the ground, handcuffing them, and throwing them to the nearest and most accessible magistrate, along with the rest of the grand jury coming along. Because we know what we're going to indict them for? Fucking treason. And we're going to hang them. That's what we're going to do, because we have the lawful capacity to do it. But nobody is doing it because they don't know the law. Okay? And yes, as Specter says, reminder, the coroner of a given county can also arrest a sheriff. That's the point. County coroner and the sheriff are the two balances of power on the county side. So either one of them can arrest the other one if one of them gets out of control, right? And any of us can obviously arrest them as well. Because the power to arrest does not just sit with the county coroner or the sheriff. It's all of our power. Any one of us in our sovereign capacity can do exactly what these men did to this sheriff. Okay? So just know that. And okay, so down to here, and I think one last section. See what 402 has to say. We're a little bit over time, so I might just stop here. I just want to see what 402 gets to. We might come back and start here later. Homestead rights to minor children. Okay, I can just read this and quit. All right. So section 99, homestead rights to minor children. Oh, well, let me finish. Hold on. Let me finish the thought about the homestead because I didn't quite get done with that. Okay. There are homestead exemptions in a lot of, but as obviously Janice said, not all states. So if there is a homestead exemption in your state, you can go get on a homestead exemption, and then guess what? You don't have to be paying property taxes anymore because your lawful domicile, your homestead, your lawful domicile and your homestead in the states where there is a homestead exemption is exempt from property taxes. You guys don't have to pay it. And all you have to do is just go read the laws. And if you want an even trickier one than that, or I should say more sly one than that, if there's not a homestead exemption in your state, find out if there's an exemption. Find out if there's a religious exemption. Sometimes they're called lodge exemptions for obviously, you know who, the filthy Masons. But if you literally set up a portion of your house as like a reading room and you say that, yes, people, my friends can come and visit here and read, and it's an aspect of our religious, whatever you want to make it up to, doesn't really make any difference. And then you create, say, a PMA, private membership organization. You establish it, put it on the public record, everybody knows it. Then you can go and get a lodge exemption for your property as well if you want. If you can't get the homestead one, you can run it through and get a lodge exemption because there's somebody I know that did that. So there's both ways of dealing with that kind of exemption. Okay, so anyway, I'll read the homestead minor rights children, then we can finish up for the night. Okay, so children, during the period of their legal infancy, are the particular objects of the protection intended by the homestead laws, right? So they're trying to protect infants with the homestead laws. And while in some of the states, a widow is denied a homestead against the claims of heirs, minor children are entitled to such in all the states in which homestead laws exist, whether the father, the mother, or both parents have died. So know that. Any state that has the homestead laws and homestead exemptions, they're going to be there for the protection of the children, okay? And so with that, I think I'll check chat and probably finish reading for the night. So Maura says, I'm friends with the coroner, and we were talking about that just the other day. Oh yeah, arresting the sheriff. Yeah, well, there you go. It's important for them to understand that they can do that. Because obviously a lot of the powers of coroners, particularly that when they used to have and be considered judicial coroners, when they had the capacity to actually run their own courts, and everybody recognized that they had the capacity to run their own courts under the common law. What they did was what attorneys do, they altered market conditions because they said, well, we don't want that. And they made them all into be medical examiners, right? They don't even call them coroners anymore. They just call them medical examiners. So anyway, that's an aspect of the history of that. Yeah, I'm done with the filthy criminals impersonating public servants as well. Yeah, they're just corporate goons is all they are, because all of them are operating in commerce and they're all doing what they're doing by the Commerce Clause and pulling over people, and it's all by presumption, right? So no one has any questions or comments for tonight? No? Okay. All right, well, I'd like to thank everybody for coming and showing up. This has been the reading of the Treatise on American Law of Administration, and you guys can download this out of the mega file that will be also labeled and put into the show notes, whether you're watching this on YouTube, on Odyssey, or Rumble, or even if you pick it up and grab it off Gab. So if you found this class to be informative, please like and subscribe and pass on the information as best you can to your fellow sovereigns. And I hope all of you have a wonderful rest of your week. And until I see you again, as always, stay safe and stay sovereign.